Hello, and welcome to the UNC Charlotte Center for Teaching and Learning webinar series. Today's webinar is on copyright in teaching and publication. We are joined today by Kate Dixon, UNC Charlotte's copyright librarian. This webinar is for informational purposes and is not intended as legal advice. If you have legal concerns, please contact the university's Office of Legal Affairs. Thank you.
And so before we get started here, I have a couple of poll questions just to get an idea of who's here and what you're hoping to get out of the webinar. So that would really help me if you guys could answer these quick questions before we get started. Okay, so our first question here is, I would just like to know what your affiliation is with UNC Charlotte so I can get a bit of an idea of where you guys are coming from with regard to copyright issues. Okay, great. Okay, so this next question is just to get an idea of how often you are encountering copyright issues in your work. So this is just copyright issues of any kind. Okay, great. So we're seeing a lot of copyright issues then. That's great. Perfect. And then here, this question is just to get an idea of specifically what type of copyright issues you're encountering. Okay, so teaching, other, and yeah, if you're putting other, it would be great if you could type that into the chat just so I have an idea. Oh, a lot of teaching. Great. All right, well, that's great because we're talking about teaching today, so that works well. So I'm going to start off today by giving you just a little bit of a refresher on copyright law in general, which we dealt with in that first webinar, but just to give you a little refresher. So copyright law comes from Article 1, Section 8 of the Constitution. And that provision of the Constitution gives Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. So I like to note there right at the beginning that the original intent behind copyright and giving copyright protection to authors was to promote that progress and knowledge. So it's really about social good, and it's not solely about money. And the Supreme Court has supported that idea. They said that the primary objective of copyright is not to reward the labor of authors, but to promote the progress of science and useful arts. Okay, so a few more details about copyright. So copyright protects what we call original works of authorship. So this could be your novel, your textbook, your piece of music, but it also involves a lot more things that you do on a more casual basis from day to day, like writing letters and emails, taking photographs on your phone, making blog posts and posts to social media. So you have an awful lot of copyrights at any given time. So in order to be protected with a copyright, works also have to be fixed in a tangible medium. So that medium could be you're writing it down on paper, you're painting it on a canvas, but it could also be the memory card on your camera or your phone. It could be the hard drive of your computer, or even putting it in the cloud. So that fixation requirement is important. And then generally, copyright lasts for the life of the author plus 70 years. There are different different rules for works of corporate authorship and anonymous works, but that 70 years is the number to remember for our purposes. And we also want to note that that number has increased a lot over the years. At the founding of the country, it was 14 years, and you could renew it for another 14 years, and that was it. So that copyright term has increased a lot over the years. And copyright holders have a number of exclusive rights. Those include the rights to reproduce, distribute, and publicly display their works, and also to create derivative works. So authorizing someone to perform a play or sell copies of their book or make a translation. So that's a very, very basic introduction to copyright in general. And so after that, we're going to move on to the first official topic for today, which is copyright in teaching. And so there are a couple of subtopics that I want to divide this into here. And that's copyright in the physical classroom and then copyright in online teaching. So we're going to start here with copyright in the physical classroom. And this is a lot easier than the online context. So we learned in our first webinar on copyright that copyright law favors uses that are nonprofit and educational because those types of uses advance that primary purpose of copyright, which is to promote the progress of knowledge. And as a result of that, Congress has included a number of exceptions to the copyright holder's exclusive rights that allow educational uses in the classroom without that need for prior permission. So when the last, I think someone's microphone might be unmuted. I'm hearing a lot of feedback, but that might just be me. Are you guys hearing me okay?
Yeah, Kate, I found who it was and muted their microphone.
Okay, great. Okay, so when the last major revision of the Copyright Act happened in 1976, most of the teaching that we're talking about happened in that traditional physical space where the instructor and the students are present in the same classroom. So the students would watch movies in class, they would view reproduced materials, listen to music maybe, but they were leaving that classroom with all those facts and notes and ideas, but without their own copies of those copyrighted materials. So today, the law still does recognize that these types of traditional, what we call face-to-face classroom performances and displays are so beneficial that they outweigh the harm to the market for the works that are being used. So to get a little bit more specific here, these are the types of uses of copyrighted materials that are permitted in face-to-face teaching. So if you are a teacher or a student in a physical classroom or a similar space that's devoted to instruction, and you're using a lawfully obtained copy, and that means not a pirated copy, so it's okay to be using a borrowed copy, and you're using it for an educational purpose at a nonprofit educational institution, so those are all the requirements, then you don't need permission to perform or display a copyrighted work in that class. So performance would be playing a movie or playing audiovisual materials, music or plays. Display would be photos, images, and text. And so note that we're not talking here about giving out copies. We're just talking about those exceptions to the exclusive rights of display and performance. All right. So hopefully that gives you a good summary. And we'll look at a little example here just to sort of see how this would work in practice. So in this example, we have a film studies professor, and she wants to show Citizen Kane in its entirety in her introductory film studies course. So the movie is going to be shown in person during the regular meeting time of the class. So what do you think? Do you think this is permissible under the rules we just laid out? And what factors would you look at in making this decision? So we have those reproduced on the right here. We have that summary of the rules. So does anybody have any ideas? You can put them in the chat, or I believe you can unmute your microphone. What do you think? Is that okay?
You could also give a green check mark if you think it's okay and a red X if you think it's not.
Yes, good idea. And I'm not sure, let's see. Might not be able to see those, but Well,
It should be to the right of the participant's name and the participant.
Oh, okay. Gotcha. All right. So everyone, yes, I think we're definitely understanding this well. So what would we be considering? We'd be looking at the fact that she's a teacher. So she's covered. She's in a physical classroom. We would want to make sure that the actual copy she's using is not pirated or unlawfully ripped. And this is for an educational purpose. Clearly, it's a film studies class, and she's showing a kind of iconic film. And if we're assuming we're at UNC Charlotte, then we're at a nonprofit educational institution. So she's probably not going to need permission to show that in her face-to-face classroom to her students. So how would your answer change, though, if instead of having a professor showing the film in a class, it's a student who wants to show the film to the Film Studies Club at the theater at the student union? What would you think then? I see some answers changing to no's. Yeah, this is a bit harder. So what would you want to look at? This is a sort of similar situation to the first example, but the problem here would be that it's not, because we have a student, it's not necessarily taking place in a classroom or that similar space devoted to instruction. So probably not okay under this exception. What could we do to make it more like a classroom? We could have the faculty advisor conduct a discussion of the movie, or maybe have a guest speaker with some expertise to talk about it, making sure we're really discussing it and dissecting it. That might get you closer to that classroom-like setting, but in general, it does need to be in that face-to-face classroom setting. And if it is just for entertainment, then we will want to make sure we're getting a public performance license to show that movie in the latter type of situation. Okay, so we're going to move on now to the trickier question of copyright and online teaching. So here we're talking about courses that are presented entirely online, but also we're talking about the online portion of courses that have both a face-to-face and an online component. And for purposes of this discussion, we're going to assume that these online courses are part of the educational activities of a nonprofit educational institution like UNC Charlotte. So you have basically three options when you're putting third-party copyrighted materials online. The first is to comply with the requirements of the Teach Act. The second is to determine whether your proposed use is going to qualify as a fair use. And the third is to obtain permission from the copyright holder. So those second and third options we covered in the previous webinar on copyright and fair use. So I encourage you to revisit that recording for more details on those options. So right now we're going to talk about option one, which is complying with the requirements of the Teach Act. Okay, so under the Teach Act, you are allowed to put online, and here we're talking about in Canvas, where access is limited to authenticated students in the class. So we're not talking about putting it on your personal website. We're talking about putting it in that authenticated space. So you're allowed to put online an entire performance of a non-dramatic literary or musical work, or reasonable and limited portions of a dramatic literary, musical, or audiovisual work, or other works such as images in an amount that's comparable to what would be displayed in a live classroom setting. So that could be a little confusing. So what is a non-dramatic literary or musical work? That would cover things like reading a poem or a short story, or listening to music, as long as it's not dramatized. So we're not talking about an opera or a musical or a music video. So that part of it is pretty limited, but in those specific cases, you can use put up the entire thing, the entire original. And then for dramatic works, where we're talking about movies, maybe readings from fiction, you can use short clips as long as you're really just like subjecting them to discussion and you're using only as much as you'd use in the face-to-face setting during the course of that classroom time. So that's what we're talking about when we talk about reasonable and limited. And so some other requirements of the Teach Act, like we said, the materials should only be available to students who are registered in the class, and they need to be authenticating to get to them. So only on Canvas, not on, say, a faculty member's individual webpage. And it's also important to attach a notice indicating that the materials are copyrighted. And under the Teach Act, here's some things that you're specifically not allowed to use. So works that are marketed as part of online instructional activities. So these are commercially available digital educational materials that are specifically created for that purpose. And this really does make sense because those materials were designed to be used and paid for in the online educational context. Also, we can't put up unlawful copies of copyrighted works if you or the institution knew or had reason to believe that they were not lawfully made or acquired. Also, textbooks, course packs, electronic reserves, and materials like that that are typically purchased individually by students for their independent review outside of the classroom. So to kind of sum up, the Teach Act is limited to the kinds of materials that an instructor would incorporate as an integral part of class time lecture. It covers works an instructor would show or play during that face-to-face class time, like those clips or images from artworks, say in an art history class, or maybe a poetry reading. It's not covering materials that the instructor wants students to study on their own outside of class. For those types of things, you'd be relying on fair use or getting permission, which we covered in that first webinar. So I would take a look at that for more. Okay, so let's do another example. So here we have the same film studies professor from the first example, but this time she's teaching a class that has an online component. So she wants to show the entire film in the course's Canvas page. What do you all think about that? We can use the X's and check marks. Do you think that is okay under the Teach Act? Let's see. I'm seeing, okay, so I see some responses on both sides of this. And this one is a little trickier than that first example. So how would we think through this? First of all, this is a dramatic audiovisual work. So we're looking at those reasonable and limited portions and not the whole thing probably. So we would want to tell this professor reasonable and limited. There aren't any really good guidelines here, so she should really focus on using only as much as she's actually going to really discuss and dissect in class, but probably we don't want her to show the entire thing. We just want to focus on that reasonable and limited. So what else might we want her to pay attention to? Making sure her copy of the movie was lawfully made, and that she's only copying those portions that she's actually going to use in class, not the entire thing. And what are some things she might do instead of putting the entire movie on Canvas? Well, she could put the movie on reserve in the library. She could contact the library to see if there is an educational license available for that. She could also require students to get a Netflix or an Amazon Prime account or Filmstruck account just for the duration of the semester. that would be a perfectly reasonable thing to ask students to do, and that would get around the problem entirely. Okay, so that hopefully gives you an idea of some of the places where copyright shows up in teaching, both online and in that physical classroom. And so now we're going to switch gears just a little bit and turn to copyright in publishing. And I'm going to approach this from the perspective of authors' rights, because I think that's a good way of understanding it. So when you decide to publish an article in a journal or publish a book, you go into that negotiation with the publisher, owning the full rights, the full copyright in that work of yours that we talked about at the beginning. Now, a traditional subscription journal, a traditional type of publisher, is probably going to require you to sign an agreement that transfers some or all of your rights to the publisher of that journal. But as the author of the work, you are the copyright holder unless and until you decide to transfer the copyright to someone else in a signed agreement. So you ultimately really do get to decide which rights you want to keep and which rights you want to give away. But if you transfer copyright without retaining any of your rights, generally you're going to have to ask permission to place the work on course websites or copy it for students or colleagues, or to deposit it in a repository, or even reuse portions of it in a subsequent work. So that's why it's important that you make sure you're retaining the rights that you think you're going to need in the future. And transferring copyright in this sort of situation does not have to be an all or nothing proposition. So the law does allow you to transfer some of those copyright rights while holding back others for yourself and colleagues and others. So how can you retain more of your author's rights? So the most important thing I can tell you first is not to automatically sign that author agreement as it's presented to you. Read it first carefully, and remember that publishers are often willing to negotiate with you on at least some points. Another piece of advice is to consult an author addendum. So these are pre-created addenda that you can either add to your agreement in full, or you can use them as a jumping off point to think of ideas for changes that you'd like to advocate for in your contract. And a good example of an author addendum is provided by SPARC, which is the Scholarly Publishing and Academic Resources Coalition. And I have a link here, but I don't think I can actually link out to it right now, but that's a good thing to look up. And then you can also, of course, just alter your author agreement by crossing out the clauses you don't like and suggesting alternatives that meet your needs better. And the worst they can do is say no. So some of the rights that you might want to ask to retain are the rights to use your work in your classes. Also, posting your work on your own website, or archiving your work in an institutional repository or a disciplinary repository, or the right to post earlier versions of your work, for example, the pre-peer review version. So what are some types of clauses to look out for? One would be the governing law and jurisdiction. So I would pay attention to any clauses that dictate which state's law is going to apply to the agreement and where any lawsuits are going to take place if there's ever any conflict over this contract. You don't want to end up in the Netherlands or even New York if there's a dispute. It would be great if you could stay in North Carolina or wherever you happen to be. Another type of clause to look out for: indemnification clauses, warranty clauses, and arbitration clauses. So these are all types of provisions that can create liability for you as an author and limit your options in the event there is a conflict over the contract. Confidentiality clauses. So these types of clauses require you not to disclose some or all of the terms of the agreement. And then again, just to reiterate, reuse and reproducibility clauses. So these govern what you and others can do with your work in the future. So does the agreement make your work open access? That's great. Does it allow you to archive a copy in an institutional or disciplinary repository? That's also great. It might attach a Creative Commons license to your work, and all of those sorts of options can increase your readership and increase your citation count. Okay, so if the publisher says no and you note your suggested edits to the contract or the agreement, and you still find the agreement to be just unacceptable to you, it's also possible to consider publishing in an open access journal. So there are lots of reputable open access journals. These are some of the places where you can check, and the directory of open access journals has a lot of reputable journals. Specific journals archiving policies can be found in the Sherpa Romeo database. And you also can check the Open Access Scholarly Publishers Association. They have strict standards for membership, so if you find a journal there, it's very likely to be reputable. And then also, just a plug for Atkins Library's Open Access Article Publishing Subvention Fund. So often open access journals do charge author fees in order to make an article open access, and you can apply to this fund and we can help you with part of that payment. And we can also, whether or not you apply for that fund, we can also help you to evaluate the credibility of an OA journal. Okay, so one more example. This looks daunting, I know. So this here is an example of a pretty typical clause from a publication agreement. So you can see that it has the author permanently granting all of her rights to the publisher, the right to reproduce and publish, etc., in all of these different formats, including formats we don't even know about yet. So how might we make something like this better? Well, one way might be just this. This is very simple. So this changes that grants and assigns language to a license for a limited number of years. So this gives the publisher that exclusive right to make money off of the work for that period of time, and then it reverts back to you. You could also have the license become non-exclusive after that initial period of exclusivity. So that's one easy way to improve something that looks so absolute at the outset. If you do retain that language of exclusively granting those rights to the publisher, you might ask them to license some of the rights back to you that are important to you. So the right to use your work in your classes, the rights, all these rights we've already talked about, the right to post your work on your website, archive your work in an institutional repository, post earlier versions of your work, etc. So even if they're getting that full grant of copyright, you can ask them to license some of those rights back to you. And another idea, of course, is to attach an author addendum, so like that Spark author addendum that I mentioned before, or to ask for specific changes from that addendum. So the Spark author addendum says that basically, notwithstanding any of the terms in the publication agreement, the author does retain the right to reproduce and distribute and display the work as long as it's for non-commercial purposes, the right to make derivative works, and authorize others to make non-commercial uses of the work. It also allows the author to comply with any of the requirements of any entity that might have funded the work. So, for example, if the agency of the U.S. government funded the research and requires that it be made available for free online. So those are some ideas of things to ask for when you're negotiating with a publisher on a difficult clause like this. And also, finally here, I want to remind you that I'm available to help you review and suggest points that you might want to negotiate as you're working through any author agreement you have. So I can't provide legal advice in my position, but I have a lot of experience reading these types of contracts, and I can help you think through that contract and come up with things that you might want to ask that publisher to change. Okay, so I think we have a couple more poll questions here at the end that will really help me as I'm planning future copyright-related webinars. I'd like to know what more you guys are interested in hearing about, and then after that, we'll have a little bit of time for questions. Okay, so this question here, I would like to know what other specific copyright-related issues you're encountering and perhaps are a bit confused by or want to learn more about. These are just some that I thought of, but if you have others, please do type those in the chat because that would be very helpful to me to know. Okay, so we have a lot of somewhat confidence. Well, that's good, I guess. Okay, yeah, this one would be helpful because more about copyright and teaching, more about fair use. And again, please, if there are other copyright issues you're encountering that you want to learn more about, please just type them in the chat and that'll be helpful. Oh yeah, and so this one is just to kind of gauge how helpful you think the webinar format is compared to an in-person workshop. Is it easier for you or about the same or, okay. And this question just addresses how much more confident you feel about tackling copyright issues in your work after the webinar. Okay. Well, cool. All right.
And I don't know.
This might be I think this is the last one. I just want to make sure you all know that you can come to me with copyright-related questions, and I hope you feel a little more comfortable with that after the webinar. But yes, please do contact me with copyright questions. Look, that is everything for what I have prepared. So if anyone has any questions.
So there was a question in the chat previously from Jim asking, it was in regards to the TEACH Act about books that are out of print.
Okay, so yeah, with regard to the TEACH Act, so posting, if you're talking about posting sections from books or parts of books on your Canvas site, there we're really talking, unless you would be actually reading those segments of the book in the physical classroom, we would really more be talking about, that would be more of a kind of electronic reserves question, and there would be looking at fair use. So it would really depend on all those 4 fair use factors, so the nature of your use, the nature of the original, how much you're using in relation to the whole, and I think what you're getting at with the out-of-print book question is that 4th fair use factor effect on the market. So we, of course, if it's an out-of-print book and they're not making money off of it anymore, there is certainly an argument that that 4th fair use factor would lean a little more towards, yes, it is fair use, but we would really want to look individually at the specific out-of-print book in the context of your class, how much of it you're using, all that kind of stuff, if that makes sense.
So there's another question. If we want to cite images in a Canvas course so that we can use images online, what's a good format of citation?
That's a good question, and I don't have any specific answer for you there. It actually would probably be up to wherever you found it, how they prefer to be cited. So in a lot of, so like on Flickr and Wikimedia, Google Images, that kind of thing, you'll often find that someone has a preferred citation format. But yeah, you would want to at least include their name and maybe a link back to where you found it. And to the extent you're in contact with the author, asking them their preferred citation format is always a great idea. Yeah, there's not any specific legally required citation format. Any other questions?
I don't know if this changes the your answer, Kate, but Jim had another post in the chat about, can I post a book in Canvas if it is out of print? So I don't know if that changes your answer to him originally.
Yeah, so it would still be a question of fair use. So we would still, like, if you have a specific book that you're thinking of, you and I could go over it in more detail, going through those fair use factors. But yeah, the out of print nature of the book does weigh into that, or can weigh into that fourth fair use factor, but we'd still want to go through the other three factors and try to balance them all in relation to your